on the Supreme Court ruling saying that no rerun election in the Kpandai constituency. The Supreme Court yesterday overturned the High Court's ruling in November 2025 that annulled the 2024 parliamentary election results in Kpandai. By a 4-1 majority decision, the Apex Court ruled that the High Court acted without jurisdiction in annulling the election of Matthew Nyindam. As a result, the planned rerun of the Kpandai election has been halted, and Nyindam's victory and seat as MP for Kpandai is restored. Well, Matthew Nyindam welcomed the ruling, saying that it affirms the will of the Kpandai voters. The National Democratic Congress has pushed back, indicating that that is not the end, and urging supporters to stay calm as they consider next steps. The minority in parliament, meanwhile, they have described the Supreme Court ruling as a victory for the rule of law. Now, this is the background. In November 2025, the Tamale High Court annulled Matthew Nyindam's win and then ordered a fresh election after an NDC challenger, his name is Daniel Nsala, he petitioned citing irregularities. The court ruled on the ruling on the matter. Everyone is crying out in favor of the NDC. Subsequently, notified the Electoral Commission. Electoral Commission notified the Parliament, and Parliament declared the Kpandai seat vacant in December 2025. You remember that on that day there was huge chaos in Parliament again. So following the declaration of the vacancy, it triggered plans by the Electoral Commission to hold a rerun around December 30. The NPP, led by Matthew Nyindam, they quickly ran to the Supreme Court. And the Supreme Court previously stopped the rerun and then agreed to hear Nyindam's challenge of the High Court's jurisdiction. And now the ruling from the Supreme Court has come that the High Court did not have jurisdiction to annul the case in the first place. So Matthew Nyindam is still MP. The elections will not be rerun. Austin Bracco Powers is joining us on the phone. He's a lawyer. Austin, thank you for joining us. Good morning to you, sir.
Good morning, my brother. I hope you can hear me.
I can hear you loud and clear. Thank you for making time for us. The Supreme Court gave this ruling yesterday. But explain to us, the NDC has been arguing about the bit on technicality. They say that the NPP won the case of the Supreme Court on the basis of technicalities and not necessarily the crust of the matter. What are they talking about?
All right. Let me say good morning to your listeners and those who are watching on YouTube. I think it is important to situate the conversation that the NPP parliamentary candidate, that is the embattled Matthew Nyindam, ran to the Supreme Court, as you well articulated, for a certiorari right to quash the decision of the High Court in Tamale. Now, here is the basis. His argument is that when you look at the representation of the people's law, particularly Section 18, it provides that anyone who wants to or who wishes to challenge the results of a parliamentary election must do so 21 days after the results have been gazetted. Now, before that, if you challenge the results before the result is gazetted, you won't make any headway because it has not matured yet. The law says 21 days after the results have been gazetted. Now, the effect of the gazette is that it gives you recognition and it gives you credibility. That's why sometimes if you wish to change your name, you will have to go and get it gazetted. It is a legal force that tells the whole world that indeed you have been recognized or acknowledged as a democratically elected parliamentary candidate of a particular constituency. So, if you file your petition outside the 21-day period or 21-day window, it means that the High Court, which is the court that hears election petition relating to parliamentary election, ceases to have jurisdiction. Now, procedure is very important. You may have a genuine right, but if you don't exercise that right within the parameters of the law, the procedure, you will lose that your right. It may be true that there may have been incidents of overvoting and other fraudulent activities, but if you fail to take opportunity of the window, the 21-day window, it means that even though you may have a genuine case, you have lost it. So Martin Yindam went to court saying that the NDC parliamentary candidate failed to file his petition within the 21 window, and that he filed it some 11 days after the window had closed. It means that the 11 days plus the 21 makes 32 days. It means that he waited until after 32 days before he filed his petition. Now, it is important to situate. I've heard some NDC communicators and government officials say that the Supreme Court should have looked at the substance of the matter. In fact, if they are well-minded and if they are aware of the jurisprudence of the Supreme Court, when it comes to sexual rights, or even the jurisprudence of the High Court, because there are only two courts in this country that exercise supervisory jurisdiction, the High Court and the Supreme Court. The Court of Appeal has no supervisory jurisdiction. So if they are well-minded of the jurisprudence governing or governing sexual rights from both the High Court to the Supreme Court, they will know that the sexual right during sexual right applications, they are not interested in the substance of the matter, whether you are right or not. They are not. They want to see whether what the law says you should have done, you did it, and what the law says you should have applied within a particular period, you really apply within a particular period. So the Supreme Court need not have bothered itself to go into the substance of the matter. They need not waste time on that. Was the petition filed on time? The Supreme Court says no, and that it was filed some 11 days after the 21-day period. So it means that the NDC parliamentary candidate has lost his right, even though he may have a genuine case. I have not yet seen the evidence they claim they are basing their hopes on, but I have not seen them. But I think that if he has a genuine case, he has lost the chance to challenge it. So the Supreme Court is saying that because of you failing to abide by the time period, you have lost your right, and the High Court has no jurisdiction. Because if you do not come, because the law is clear. When you look at section 18, it says 21 days after the gazetting of the results. And in fact, when you look at 18.3, it was clear. It says this period shall not be extended. In fact, it makes it clear. When in law, when we say shall, it is mandatory. It says this period shall not be extended. It means that the 21-day period, no court in this country and no executive power can be used to extend that period. So he lost the right, and the Supreme Court decided. Now, there are two consequences flowing out of the Supreme Court's decision. The first is that
Austin, we'll get to the consequences later, but help us understand this, that some of the reasons or the arguments some other people are working with is that there were two gazetted results from different dates. What should inform which one is the one you should go for? The NDC was working or proceeding on the assumption of one of the dates, one of their gazetted results, and then the MPP was also proceeding with one of the gazetted results. What's the dynamics of that?
No, the thing is that it is an issue they will have to deal with the Electoral Commission, because the thing is the Electoral Commission first, and I think the Electoral Commission first published the results, but it was incomplete. Then later they published a final one, I think some other day period. But the thing is that on what basis was Yindam sworn into Parliament, or sworn in as a member of Parliament? It was on the first gazette. If he was sworn in on the first gazette, then clearly the courts will have to look at the first gazette. If he was sworn in on the basis of the second gazette, then the second gazette, and I know the NDC is basing its position on the second gazette, that because of when you look at the timing, they have enough time, or they filed the petition within time.
Exactly.
And I know the MPP too is looking at the previous gazette, which was the basis upon which Martin Yindam was sworn in as a member of Parliament. I think the Supreme Court made the right decision, because these are administrative matters. You have to look at whether or not the first gazette in any way, or let me say, whether or not the second gazette derogates from the first gazette, or in any way invalidates the first gazette. If it does, then the first gazette loses its validity. But if it does not, and it only enforces or it only complements the first gazette, then the first gazette has relevance. So I think the argument the NDC was advancing before the Supreme Court In fact, it was unpersuasive. If he had been persuasive, looking at the margin, 4-1, I'm not sure if the argument had been persuasive, they would have had somewhere 4-2, or let me say 3-2. They would have had 3-2, which would have given them an opportunity that when they go for a review of the decision of the Supreme Court, they are likely to succeed. But 4-1 is too heavy and too straight a win that if you go for a review, it doesn't look good for them.
So let's now talk about the consequences, the impact that this ruling will have. First, on the happenings in Parliament. And then second, but the most important for us right now, is that based on the ruling of the Supreme Court, on the back of the 2 gazetted results, what consequences does this ruling have on future election petitions of political parties who may have similar concerns in the future?
Yeah, so it is important to bear in mind that this decision of the Supreme Court, first of all, terminates the appeal before the Court of Appeal. Don't forget, Martin Yidam is also before the Court of Appeal to challenge the decision of the High Court, Tamale. So, and he also filed the certiorari application, in fact, so that they move consistently. Whichever process is head first will help him or terminate the matter. And God being so good, he has been able to secure victory from the Supreme Court. So it terminates automatically the case before the Court of Appeal. So the Court of Appeal must dismiss the case because now the Supreme Court has said that the decision made by the High Court, Tamale, Judge, Justice Bat Blanche, it is not legally, it has lost its legal vitality because it was made without jurisdiction. So it terminates it. Secondly, it says Ghana money. Because don't forget that the Electoral Commission was planning to conduct a by-election at the constituency.
Yes, Kpandai.
So it is saving us money, so that the money will now have to be rechanneled into something that will help or create jobs and create, it boosts businesses and development in the country. So I think the Supreme Court has said that the controversy in Parliament, and clearly it settles the conversation in Parliament. I think it is important to commend the Clerk of Parliament and the Speaker. The thing is that it was argued that the Clerk of Parliament may have misconducted himself. I think he did his job. When a court of competent jurisdiction makes a decision, even if you disagree with it, and even if you think that the decision was so bad, you still have to respect it until an upper court dismisses or invalidates or passes the decision. You must respect it. So the earlier position taken by the opposition New Patriotic Party was way over the board. And I think they should be learning from it. Sometimes we must not be too we shouldn't over-politicize certain events. A court of competent jurisdiction has made a decision. And I've said that when if a judge can make a right decision, that judge can make a wrong decision. So when a judge makes a decision which you feel was bad, you must not be or run to the press or the media and be saying all manner of things against the judge and against the court. Now, the Supreme Court has given you a favorable decision. What are they going to say about that? Will they say the judges have been compromised and the judges did not take the right decision? Sometimes it is a challenge I'm throwing to both the opposition New Patriotic Party and the governing National Democratic Congress. Let us be measured in our utterances. If a judge can make a right decision, that judge can make a wrong decision. So when a judge makes a wrong decision, do just follow the process and challenge the decision. But don't be in the media to be criticizing and be passing scathing comments against the judge. It doesn't help our system to grow. So it is good that the clerk did his work, and now I think if they have anything, if they have any claim against the judge, the clerk, they should withdraw it. That clerk only did his work. If they have any issue, it is the court that made the decision. So this decision of the Supreme Court has 3-pronged effect. Which I told you, it terminates the case before the Court of Appeal. 2, it prevents the Electoral Commission from going ahead with the by-election. And the third one is that it vilifies, or in any way it gives volume to the work that Parliament did. Parliament did a good work because when a court makes a decision that you should not hold yourself as a member of Parliament, they must insist upon it that you should not hold yourself up as a member of Parliament. Just because the court has said it. Although an upper court, it overturns it. So this is what we should have in mind.
Okay, but in terms of gazetting concerns, when in the next election there's another concern by a party, which of the gazetted results should the aggrieved go to court with? Should it be the most recent or the original?
So clearly, earlier I said that in cases where there are two gazettes voting on the same matter, first of all, you must look at whether the subsequent one invalidates the previous one, or whether the subsequent one in any way it gives further expression to the previous one. So we must look at the two. When there's a gazette, there's a likelihood when there's an earlier gazette, there's a likelihood that there may be a further one if there are clerical mistakes, errors that the Electoral Commission may have made. So the Electoral Commission may indicate that there were clerical errors in the previous one. So this subsequent one takes precedence over the first one. So they must be able to understand them. And I think it is also a challenge to the Electoral Commission. Stop making some of these petty mistakes. It is hurting our democracy. Imagine the stress these two competitors went through. If the Electoral Commission had done its work well, I'm not sure we would have been here. Look at the national trauma. People are talking about it, the press, occupying spaces. In fact, the Electoral Commission has a lot to do. And that the thing is that if they have done their work well and be consistent in whatever they did, they would have saved us money. And I think they must be careful going forward. Because this should drive reforms at the commission. Don't publish multiple gazettes bordering on a particular matter. One gazette to border on an issue, and that is it. And if you are not ready, if you don't have the full confidence of the fact, wait. The Electoral Commission is causing us so much trauma and so much financial cost, and it is unbearable. We need to be driving some reforms over there.
And now, Austin, for the NDC, since they may not be very pleased with the ruling of the court, what options do they have?
I think it is important for the NDC to know that at certain times, certain point in time, you must learn to withdraw, reorganize, and move forward. I have heard some members say that they are going to invoke the review jurisdiction of the Supreme Court. Oh, it's fine. It is within their right to do so. But sometimes you look at the technicalities. In fact, to get the Supreme Court to review its own decision, it is clearly circumscribed. You must prove exceptional circumstances. And for me, what I've heard them say, being the exceptional circumstance, is that the case has a merit. And I'm saying that Jesus Christ, if a case has a merit, it has no room when it comes to certiorari application. If a case has a merit, it is the trial court that must determine so. And the trial court lacks jurisdiction. So even the merit of that case is lost. I am saying that the NDC must admit honorably that this case they've lost it. Don't go for review because it won't be good for them. Because what exceptional circumstances are they going to show, exhibit to the Supreme Court? In fact, the Supreme Court panel, which will be more than the five that they had, that there's a exceptional circumstance which the original panel did not take into consideration, or which was not in their contemplation at the time they filed they challenged the certiorari application. It doesn't look good for them. They should let the seat go. They should let Martin Udam serve his people and organize for 2028. This thing, I'm telling you, 4-1 is not easy to convert 4-1 into 3-2. It's not easy.
I see.
In favor of the NDC, it's not easy. I think they should honorably concede. This is the decision of the court. And I've said that it is their right to exercise, but sometimes when you look at the technicalities and whether or not you meet the threshold of review, the threshold that has been set for the Supreme Court to review the decision, it is not meaty. Don't go. Other than that, you are wasting everybody's time. Let's progress as a nation. We have a lot to do. We have a nation to govern, and we have a nation to determine. So I think they should let this one go. They have the super majority in Parliament. Concentrate on passing the relevant act and concentrate on the 24-hour economy they promised, and there's a 133 issue. Let's see evidence of that policy so that stop some of these needless partisan politics.
Austin, thank you so much for your time with us.
Thank you.
Austin Bracco Powers is a private legal practitioner explaining the happenings in the Supreme Court yesterday for us. But my colleague Christopher Mwaku, he has been in the Kpandai constituency. Matter of fact, Since the journey of Matthew Ngindam began, or the struggles of Matthew Ngindam began in the court, he has been in the constituency and he's joining us to tell us exactly how the constituents have managed themselves in this roller coaster from the contestation of the results to the ruling of the High Court in Tamale to the applications of the Supreme Court and then the final ruling. Chris, walk us through the journey from when the elections was declared in 2024 to the concerns of the NDC and the NDC subsequently taking the matter to the Tamale High Court and all the journey. Talk to us.
Yes, so Crosby, I must say that after the 2024 parliamentary election in Kpandai, one of the reasons why the NDC candidate, Daniel Nsala, who lost that election, took the matter to court was because the coalition of some of the polling stations, according to him, were done at his blind side, because he says that the designated polling station that they were all supposed to go, coalition center that they were all supposed to go and have the election results that were coming from the various polling stations to be compiled was changed at his blind side. And so he is saying that as a result of that, it's also accounted for his opponent, Matthew Ngindam, being declared by the Electoral Commission because he believes it was planned. Now, the second issue has to do with that he said there were some irregularities in some 41 polling stations, and so he needed the court to have a look at it and ensure that justice is served. Fortunately for him, after some 11 months in court, the Tamale High Court ruled in his favor. And so it was jubilation all over, right from the court premises to the Kpandai constituency in the Kpandai community as well. And so after that, the MPP candidate, Matthew Ngindam, who is now the Member of Parliament, as ruled by the Supreme Court yesterday, and also his lawyers, immediately after the ruling, filed an appeal at the Tamale High Court. They also proceeded to the Supreme Court to file a stay of execution and to also pray the Supreme Court to ensure that the EC does not go ahead with the organization of the rerun as ruled by the Tamale High Court. And so we have visited the Kpandai constituency severally since the back and forth of this matter. One critical thing for residents, in the beginning there were some divided views, because while others really wanted the rerun, because they believe that once there's going to be a rerun, they will get development as have been seen in other areas where there's been by-elections. So because the ruling government wants to win the seat, they will come and begin some projects, and some will be completed, so they will get their fair share of the development because of the rerun. Others do believe that it is going to be waste of resources, because the candidates and the parties will rather come and be sharing goodies to the electorate instead of looking at development. So there were divided views from the beginning, but majority believes that the peace of Kpandai was paramount, and so with or without a rerun, the people must ensure that the place remains peaceful and calm. Yesterday, finally, the Supreme Court gave its ruling in favor of Matthew Ngindam. There were a series of jubilations in the Kpandai community and the entire constituency, even though it was done in moderation, because the people believe that the victory is not that of Matthew Ngindam or the MPP. The victory was for Kpandai's development. And so right about then, all they were thinking about is how Matthew can make up the lost time and be able to develop the Kpandai constituency for them. They also believe that Nsala should wait. Maybe 2028 he should come and try his luck again. If the people see that Matthew Ngindam has not lived up to expectation and he wins his primaries, he will be given the opportunity if they see the need to. But for now, he should relax and support Matthew Nyindam to succeed in Parliament. Now, the other issue has to do with, as we speak, the peace of Kpandai has been maintained. There hasn't been any incidents of attacks, abuse, confrontations, and others. The place has been peaceful since yesterday when the Supreme Court gave its verdict on the Kpandai constituency. So, all in all, Crosby, I can say that Kpandai is peaceful. I'm reliably informed that today Matthew Nyindam is expected to be in the Kpandai constituency, because yesterday the party chairman told me that they will be bringing him home to a rousing welcome. So we are hoping that he will come and address his constituents. But some of them are really happy that yesterday, when Insala Wakpawa was being interviewed by a media general reporter on the ground at the court premises, he emphatically mentioned that he's happy about the peace that is prevailing in Kpandai. And so a lot of people have commended him for thinking about the peace in Kpandai, and they are also telling him to let this matter rest so that they see how they can support Nyindam to develop Kpandai.
I see. Chris, thank you so much for the elaborate reporting. Christopher Amwako speaking to us on how the journey in the Kpandai constituency has been throughout this period, about 11 months of back and forth in court, contesting the Kpandai parliamentary election result, which was declared null and void eventually by the Tamale High Court, and then it was taken to the Supreme Court by Matthew Nyindam yesterday. He got a favorable decision, a 4-1 majority decision. Well, the sides of Parliament, they have been reactive. First is the minority. The minority in Parliament, they have welcomed the decision of the Supreme Court of Ghana to quash what they call the deeply flawed judgment of the Tamale High Court, which purported to annul the 2024 parliamentary election in Kpandai and to set in motion, they're calling it a needless rerun. Well, they say that the landmark ruling restores the unequivocal mandate freely and lawfully conferred by the people of Kpandai on their member of parliament, the Honorable Matthew Nyindam, and reaffirms the primacy of the constitution, due process, and electoral finality in our democracy. In so doing, the court has underscored a basic but vital principle. No court, no party, no institution of state may, under any pretext, rewrite the rules after an election has been held and a winner duly declared and gazetted. Where the law says a petition must be filed within a fixed window from the date of gazette, any action outside that window is a nullity, and any judgment founded on such petition cannot stand. That is the clarification on the jurisdiction and timelines giving. Well, the effect of this ruling is that there will be no rerun in Kpandai, and that the Honorable Matthew Nyindam remains in law, and in fact, the duly elected member of parliament for the Kpandai constituency. This judgment, according to the minority, referring to a systemic correction of Ghana's democracy, this judgment is not only a personal vindication for the sitting MP and the people of Kpandai. They say that it is a systemic correction that will resonate far beyond a single constituency. It sends a powerful signal to all trial courts that in election matters, strict compliance with jurisdictional thresholds, timelines, and the limited range of remedies set by statute is not optional. In light of this development, the minority calls for the following. They're making a few calls. Number one is that an immediate and formal withdrawal of any residual notifications or administrative acts suggesting that the Kpandai seat is vacant, so that the records of Parliament and that the Electoral Commission accurately reflect the Supreme Court's decision and the continuing mandate of the Honorable Matthew Nyendam. They are also asking for this, that a thorough internal review within Parliament under the leadership of Alban S.K. Bagwin to ensure that in future no notification of vacancy is issued whilst appeals and applications for stay are pending unless a final court expressly directs otherwise. You remember this this ruling, this call by the minority? I think we should note it because, of course, in subsequent happenings in Parliament, it may come up that the Speaker of Parliament, okay, the earlier one, that the Speaker of Parliament should ensure that in future no notification of vacancy is issued while appeals and applications for stay are pending unless a final court expressly directs otherwise. That is the second call to action they want. Also, a recommitment by all sides of the House to the long-standing parliamentary practice illustrated by the Abodakwi, Sakande, Nyimakan, and Kwesing experiences of respecting the hierarchy of courts and awaiting final judicial determination before taking steps that permanently will affect representation and the composition of the House in Parliament. They are also taking note of the statement by the National Democratic Congress indicating its disagreement with aspects of the decision and its contemplation of a possible review. The minority affirms that in a constitutional democracy, even strong disagreement with a judgment must be expressed through lawful avenues, reasoned critique, academic debate, and where available, the structured review procedures of the Supreme Court itself. We must never recur. What must never recur, they say, that is the attempt to weaponize an unfinalized judgment still under challenge to alter the composition of Parliament and to send an entire constituency back to the polls prematurely. We extend our collective appreciation to the bench, and they're talking about the Supreme Court justices, although the full judgment is yet to be released by the court. Now, we understand that the full judgment will be released by the 6th day in February. Now, the summary reads today, according to the minority, serves as an indication that the certified judgment will provide a crucial clarification of the law on jurisdiction and timelines in election petitions and reinforce the constitutional balance, okay, between judicial scrutiny and respect for the people's vote. This is the minority's response or their reaction to what happened in court yesterday. After the ruling of the Supreme Court, there are those who say that because the ruling has gone in their favor, they are happy about it. If the ruling had not gone in their favor, what would have been their shout or their cry? I mean, you never know. We can only assume. Well, this is still Sunrise on 3FM 92.7. We're live also on all our social media platforms at Facebook at 3FM 927. We can get interactive there. What you make of the ruling from the Supreme Court and the journey so far of Matthew Nyendam in Parliament, but as it stands, he is the duly elected Member of Parliament for the Kpandai constituency. We'll be back shortly to talk about the Ayawaso East constituency, the NDC primaries, which are set up very nicely. In a moment, we'll talk about it.
3FM Sunrise.